One way creditors can recover money from a company is with a statutory demand. This demand, made under the Corporations Act 2001, gives the company's director 21 days from the date it's received to pay a specified sum of money. If your client receives a statutory demand, they have 21 days to either pay the debt in full or dispute the debt and apply to have the statutory demand set aside. But they need to act quickly. If they don't act within 21 days, the creditors can use their failure to comply as proof that the company is insolvent. They can then file an application with the court to appoint a liquidator and wind it up. Here at Rapsey Griffiths, we talk to a lot of company directors who've had winding up applications made against them. And in a lot of cases, it happened simply because they didn't act within the 21-day timeframe. Unfortunately, once the application is made, their options for dealing with the debt, other than to pay it, are significantly reduced. For example, instead of being able to appoint their own liquidator, they have to settle for whoever the creditors choose to wind up the company. And while the director can appoint a voluntary administrator to try and save the company and restructure its affairs, the fact it's insolvent makes the process more expensive. So if your client receives a statutory demand, help them avoid receiving a wind-up notice by talking to Rapsey Griffiths as soon as possible. With our professional advice, you'll be able to give them the widest range of options for dealing with their company's debt and minimise the risk of it being deemed insolvent.